Hello, everybody, and it's good to be back with you. I'm speaking with you from Cooperstown, New York. I have the pleasure of being here to deliver remarks later in the afternoon at a conference. As a baseball fan, it is always a thrill to swing through Cooperstown. Of course, we are back in baseball season, and I can already begin to stress about the Mets, who are, as typical, mediocre. But I digress. It is nonetheless, absolutely beautiful here. I hope the same for wherever you are tuning in from. We have a lot to talk about today, and I am happy to walk you through the agenda. So if Kathy, you wouldn't mind please advancing, that's great. Thank you. Let me go ahead and do that. So I will be addressing the budget in a moment. We have a handshake in a certain sense here in New York State. I'll explain the details in a moment. And I'll walk through what we expect to be in the final budget. We don't have a final budget yet, to be clear. And then Seth Gilbertson, who has been on the program numerous times, will be back with us from Buffalo. He's looking at education law and essentially the intersection between certain requirements and whether people can exercise essentially religious freedoms in the context of those laws. It's an interesting interplay that we thought for all of you practicing in the higher ed space, particularly in New York, be interesting to know more about. Kate Hajar is with us as well, someone who has been on the program numerous times with us from New York City. And there are upcoming reporting requirements on July 1st that relate again to institutions of higher education that Kate will walk you through. Emily Iannucci is back on the program after a bit of a break. Last appearance was during the heart of the pandemic, and thank goodness things are better. And we're glad to have Emily here to talk about something from her practice, focusing on labor law and essentially the access that employers have to personal account information as a result of some changes here in New York State. Then finally, among our scheduled speakers, it'll be Travis Tellerico, who's with us again, a regular on the program, back with us from Rochester. He's going to be looking at EEO data and the opening of a data collection period later this month. So with that outline in mind, let me get to the substance of our presentation. And I'll start with where we are on the budget. And so as noted, there is this conceptual agreement that the governor announced yesterday afternoon, and it's a $237 billion budget, which is approximately $4 billion more than where things stood as the governor proposed the budget in January. Interestingly, neither the Senate nor the Assembly leadership joined the announcement. What I've read and otherwise heard is that there's still lots of negotiation happening behind the scenes, and that from the perspective of the Senate and Assembly, there are some unsettled details. And it is not the case that everything has been worked out. But as far as the governor is concerned, most of the large items that represented her priorities have been settled. There are bills, of course, that will be released in the context of getting this budget finalized, and that's when we will all be able to, with much more discernment, tell you what's in, what's out. That'll be the subject of next week's webinar when you'll have, presumably much more opportunity to dig into the details. And so I don't want to get in front of that conversation other than to just tell you that we expect in between now and then for much of this to be clearer. In the interim, the state continues to operate with budget extenders, which essentially keep us utilizing the preceding budget that was to have expired on April 1st. One thing that also isn't settled is whether we have the $4 billion or so concerning the managed care tax that's gotten a lot of attention baked into this budget. What is suggested based on some of the news being reported is that New York State is going to essentially, through this budget, suggest, if not telegraph, that it's seeking formal permission from CMS to go ahead and seek what California has effectively implemented, among others, but we don't know exactly how that lands yet. We can go to the next slide, please, and let's talk about what some of the elements are. Thank you, Kathy. That we do know are in there, unless, again, things change as we move from this conceptual framework. There is a housing deal that is rumored. It is going to include a replacement to the 421A program. You all may remember that during last year's budget cycle, the governor pushed very hard for a comprehensive approach to housing, ultimately that the legislature collectively pushed back upon, and it wasn't included in the budget that was approved a year ago. This year, it's the governor's belief that a substantial amount of headway has been made, and what we will see is a significant framework concerning the production of affordable housing, loosening of other requirements that may facilitate that. There are interplays between development and other elements that have yet to settle. And again, we will provide you with further updates in a week. Cannabis is also very much on the governor's radar, as well as many other lawmakers, of course, because we have seen the bumpy rollout. I think that's fairly described, no matter from which angle you're approaching it, regarding what it has been to legalize cannabis in New York State. There are lots of illegal sales taking place. There are more enforcement tools that are evidently in this budget to try to counteract that. And we will tell you more as we learn about it. Another really big item is, again, what's suggested to be about a $500 million savings. We've talked about this before. That involves the Consumer-Directed Personal Assistance Program. This is being very hotly contested by fiscal intermediaries and those otherwise that are in support of this program, which in many respects is designed to provide services for individuals who are in their homes, often by people who are known to them, neighbors, loved ones, etc. So that program, though, from the governor's perspective, has become more costly than the state can manage. And so there are significant changes in its architecture that are, again, we understand, part of this budget. More to come. And then with regard to other priorities of Governor Hochul, retail theft is a place where the governor has been public in her comments more than once as a place where she wants to be present for small and other businesses in New York State, where in many respects, in connection with the pandemic, we saw some upticks depending on the market in that nature of theft. And so there are various criminal penalties and other tools that we understand to be in the budget that are going to increase law enforcement options in that space. And we also see language around hate crimes, which is another priority of the governor. For New York City listeners or others who are interested in those politics and the policy, we know, based on what has come out publicly, including Mayor Adams making public statements with appreciation for it, the public schools will remain under mayoral control, specifically that of New York City and Mayor Adams, for 2 more years. And then there's also a significant amount of funding in connection with services for individuals who have entered the United States, and many of whom are in New York City and elsewhere in the state. The governor has sought to earmark funding to be responsive to those needs. So with that, as we learn more, you can expect to hear from Kristen Smith and others on the team regarding what it is that's in this budget. But for now, that should give you a flavor, and really glad that we could provide you with the snapshot. And I'll turn to the introduction of our first speaker beyond myself for the afternoon. And that's Seth Gilbertson, who's with us from our Buffalo office. And he's looking at this interesting issue in education law, 224A, and this interplay that I was describing. Seth will get into the details a little bit more thoroughly. And for all of you in IHE space, please take good notes. For those of you who are not, but wish to learn about some of the thorny issues that leaders have to contend with, I'm sure there'll be a lot for you to take in here as well. Seth, the floor is yours. Thank you for coming back.
Thanks, Gabe. Next slide, please. All right, so the primary law that I'm going to focus on this afternoon is New York State Education Law 224A, which is not a new law, but it's received what I think we can fairly describe as increased attention, as have many religious liberty types of issues over the past year in higher education, often in response to increased anti-Semitism and Islamophobia that we saw and we continue to see in the wake of war in the Middle East and turbulence there, and how that's affected our campuses back here. So 224A is not a new law. It's from 1966 actually, but I think it's fair to say that it's also not one that many educators in New York think of often. It does apply specifically to all colleges and universities in New York State, and I'm going to talk about our friends from outside of New York who are with us and how some of these laws might apply to them as well in a minute. But focusing on New York State law, this law, again, been on the books since 1966. Really what it requires more than anything is that students be allowed to miss time for religious observances, whether they be missing class, study requirements, exams are a big one. Maybe there will be extension of papers involved, things like that. This often, since many of the traditional Christian holidays are already sort of intertwined into the academic calendar, a lot of times this comes up, for instance, with the Jewish High Holy Days. We just saw we just finished the breaking of the feast for Ramadan. Some students may have taken time off for that to celebrate their beliefs and need time off. What the law really requires is that institutions allow students to take that time and then find ways for them to make up the lost credit, the lost exam, the additional time to write the paper, that kind of thing. Students technically under the law need to give 2 weeks notice. That's important to have in your policy. Next slide, please. And the policy is really a big part of this. There is a non-discrimination piece. We all know that we shouldn't be discriminating against individuals based upon their religious beliefs already, but you also can't discriminate against them for taking time to observe religious holidays and such. That would be an extension of non-discrimination based on religious belief anyway, but we've got it sort of restated here in this law. And then this last piece is the one, again, that I want to focus on most for our clients in the higher education world. It's a good time to take a look at your policy, because the law doesn't say you need a quote unquote policy, but it does say that you need to provide notice to students as to how that they have these rights and as to how they should go about seeking to utilize their rights in this area. So make sure you have a policy. There have been a lot of studies lately that show many institutions actually do not have these policies. And those aren't New York specific, but nationwide. In the private higher education sphere, only about 60% of institutions have a religious accommodation policies. So we want to make sure we have those. They're more common on the public side because you also have constitutional issues to contend with. I'm not going to get into that today because frankly, that's a whole webinar on its own. So for our public institution friends out there, we're happy to talk through the constitutional religious accommodation issues, but that's not what we're here to talk about today. So go back, look at your policies, make sure you incorporate absences, make sure you have a notice provision, make sure you tell students where to go to seek these accommodations. And next slide, please. On the federal side, so that's sort of the New York side dealing only with absences. On the federal side, we have fewer protections, surprisingly, although they do tend to be, I would say, expansively interpreted by both regulatory and courts, particularly in recent years. Title VI does not actually specifically, technically apply to religious beliefs, does not prohibit discrimination based on religion, but it does prohibit discrimination based on shared ancestry or ethnic characteristics, which are often closely correlated with religious beliefs and often interpreted by the Office for Civil Rights and courts as sort of incorporating non-discrimination based on religion into that sort of mix of the protections under Title VI. So Title VI also does not specifically require accommodation. However, it does require non-discrimination. So if you're offering accommodations for secular types of activities, even health-related health or family-related obligations that students may have, then you may also be required to allow some kind of accommodations for religious observances. The other thing that Title IX or Title VI requires, sorry, is a procedure by which students can essentially come and file complaints that they believe their Title VI rights have been somehow violated. I think Title VI certainly requires that faculty and staff understand those rights. Now, what I will say is not every faculty member or staff member needs to know the specifics of it. What they need to know is where to send a student who has a question. So whether that be your EO administrator, your chief diversity officer, wherever that office may lie on your campus, make sure that your staff and faculty know that if a student comes to them with an accommodation request, that they send that student to the right office so that they can properly make that request and it can be evaluated and ultimately given based upon the student, the requirements of the law and the policy. Next slide, please. Finally, just a few practical advice. Again, go back, look at your policy, make sure it should appear in your student handbook or somewhere else that's very visible to students where similar policies are contained. Make sure that you have an office that is specifically assigned to handle religious accommodation requests, so that you have some people who are fluent in this area and know how to handle the requests, and they're sort of it becomes routine for them, and it's easy then to tell faculty and staff where to send people. Be flexible when you're dealing with students in this area, particularly with regard to 224A. The law does not distinguish between well-known religious. I just mentioned Jewish faith, Muslim faith, Christian faith. Those kinds of ones we're kind of used to dealing with because they represent a larger number of our students. But there is nothing in the law that says it has to be a well-known religious or well-known and organized religion in order to have protection under this law. So if a student comes to you with a unique set of beliefs, you should consider those on the same grounds that you would consider a Jewish student or a Christian student's request. 223(4)A also does not specifically allow for or have an undue hardship or reasonableness standard written into the law. That doesn't mean that there is no level of reasonableness or point at which the number of absences or the timing of the absences in some rare situations may not have some bearing on whether or not you're going to grant the request. But if you're going to be denying those requests, I encourage you to reach out to your lawyers to discuss that, because again, the law has no specific undue hardship or reasonableness standard. And then finally, I just want to note, look at your own policies that you have. I've encouraged you already to look at your policies and make sure they comply with Title VI and with 224A, but also just look at the statements that you make in your mission and your non-discrimination statements. See what kind of promises you're making and make sure that you're following through on those. One of the easiest ways legally for an institution to get themselves into trouble is to not follow their own promises, their own statements, their own sort of contracts they made with their students, and make sure that they follow through on those. So thank you. With that, I'll pass it on back to Gabe.
Thank you, Seth. Really interesting guidance. And of course, as you said, it's a good time to look at, what it is you're doing as institutions so that if you need to make tweaks and adjustments, you should certainly do so. And attorneys at Bond, particularly those you have comfort with, can help you with that. So let me turn to Kate, who is our next speaker. And we're staying with the higher education theme for a moment. And Kate is here to talk about July 1st filing deadline, essentially concerning various forms of harassment that are documented on campuses. There are ways that this gets done right and well. Kate can walk you through all of that. Kate, I thank you for being on the program again and representing the New York City office. The floor is yours.
Thank you, Gabe, very much. Good afternoon, everyone. I'm very pleased to join you again to share this alert, this new compliance deadline that's coming up on July 1st, as Gabe said, of this year. This compliance deadline pertains to Article 129A and 129B, which I'm sure those of you in attendance at a higher education institution are well aware of and very familiar with. It's important to note that this July 1st deadline, compliance deadline, is distinct from and different from the annual filing of certificates of compliance that many of you are, I'm sure, very familiar with, where you file one single form certifying compliance with these two articles of the New York State education law. What's coming up this July is similar to the original submissions that we all made in 2016, roughly 10 years ago, where institutions are going to have to file actual documents, actual copies of policies and procedures that demonstrate their full compliance with these two articles. It is our understanding that NYSED, the New York State Education Department, will be collecting these documents from institutions via the IRS Data Exchange portal, which is the same portal. Thank you for changing the slide. Which is the same portal in which we do upload the certificates of compliance every year. They promise further instruction on how to make a compliant submission. So everybody should be monitoring the NYSED website for updates in that regard. It's our understanding that once all the policies and procedures have been uploaded, that NYSED will be reviewing those policies and procedures for compliance. What can we do now? So if you can just change the slide, thank you. What to do now? This is a great time this spring. It's only April, but these deadlines come up fast. But April is a great time to start looking at these policies at your institution for compliance generally with 129A and 129B. It's been probably 10 years since you've looked at these policies for specific compliance with these articles. And a lot has happened in the Title IX space also in that interim. And it's possible that as we've been paying a lot of attention to Title IX, some of these state law requirements may have gotten lost in the shuffle. So it would be prudent to take a look at our policies now to make sure that Articles 129A and 129B are fully covered. And our team here at Bond can certainly assist with that if so desired. Beyond looking at the policies for compliance purposes, you're also going to want to start a collection process. And some of the documents that you're going to want to collect to demonstrate compliance with 129A and B are listed below. This is not on this slide here. This is not an exhaustive list. It is a collection of the types of documents that you may want to start looking for. They include, rules for the maintenance of public order, procedures for investigating hate crimes. These are 129A elements, fire safety disclosures for residential students, the definitions of affirmative consent and amnesty, provisions for drug and alcohol use. These are speaking to 129B. All of these elements may be contained within one or two larger policies, but they are important elements of the law that you're going to want to make sure you check off and make sure that the documents that you're collecting fully cover. So we are keeping an eye on this. We are working with our clients to make sure they are fully compliant in this area, that they're collecting the right documents. We are going to keep this group updated via this weekly webinar or via our blog. That's been is a good resource. We encourage you to subscribe to that if you're so inclined for updates. And if you have any questions along the way, please reach out to us or any attorney at Bond that you typically work, and we're here to help. Thanks, Gabe.
Hey, thank you. And really very much a pleasure to listen to your presentation. We thank you for delivering it and for providing the group with tips on how to get ahead of this reporting deadline and otherwise what might benefit from refreshment. Let me turn now to Emily Iannucci, who's with us from Garden City, and Emily is a member in that office. I have the pleasure of working with Emily through the Government and Regulatory Affairs Practice Group. Emily is a member of that body as well. And Emily is here, though, putting on her labor attorney hat and focusing in specific on changes in personal account protections vis-a-vis employers that employers should be paying heed to. This is something that we've talked about as it was on the horizon on the webinar before, but now it's actually here. And so, Emily, thank you in advance for this briefing. Welcome back to the program.
Thank you, Gabe. Good afternoon, everyone. I'm Emily Iannucci, and I will be speaking to you briefly about Section 201I of the labor law, which just became effective on March 12th of this year. The law generally prohibits employers from requiring employees or job applicants to disclose their login information for personal accounts, including social media accounts. New York is not alone in this area. There are 10 other states which have already enacted similar legislation. So New York just joined them in doing so. And before we get into specifically what is prohibited, I think it's important to understand which employers are actually covered by this law. And the answer to that is basically all employers in New York State, with the limited exception of law enforcement agencies, fire departments, and departments of corrections or community services. So unless you're one of those few employers, you are covered by this law. So listen up. So what specifically does the law prohibit? First, employers cannot require any employees or job applicants to disclose their username, their password, or any other login information to allow the employer to access the employee or applicant's personal account. And to be a personal account, it has to be exclusively used for personal purposes. Second, employers cannot require any employees or applicants to access their personal accounts in the presence of the employer. So you cannot call an employee into your office and make them log into their account in front of you so you can go snooping around. Third, employers cannot require any employees or applicants to go into their personal accounts and reproduce photos or videos or really any other content from their personal accounts and give that content to the employer. And last but not least, not surprisingly, employers are prohibited from any kind of retaliation against those who refuse requests to disclose such information. So now let's talk about what employers can do. First, employers can still require employees to disclose their login information for their company accounts. So if for some reason an employer needs to get into one of its employees' accounts, the employer can still do so. Second, employers can require employees to disclose their login information for accounts which are used for business purposes. However, under such circumstances, the employer should have given the employee prior notice that they don't have a right to privacy in such accounts. Third, employers can still require employees to give them access to any electronic device that is paid for in whole or in part by the employer, with the condition that at the time that the employee accepted that device, they agreed that as a condition of the employer paying for that device in whole or in part, the employer would have access to the device. However, under those circumstances, the employer would still not be able to go into any personal accounts that are on that electronic device. And fourth, employers can still restrict employees' access to certain websites on the employer's system. So for example, if you're an employer and you don't want your employees going on Facebook during working time, you as the employer have the right to restrict their access to such sites while using your system. Fifth, of course, if an employer is given a court order which requires them to ask employees for such information or access employees' information, employers are still permitted to comply with the court order requiring them to do so. And last but not least, employers, can still check employees' public accounts. If, for example, an employee comes to you and tells you that they saw something on Facebook that another employee posted about being in the Bahamas on Friday, and that employee who was allegedly in the Bahamas had called in sick that day. If that employee who was allegedly in the Bahamas has a public Facebook account, you can still go check that public account and use information that you see from that public account to investigate whether there was misconduct or any kind of sick leave abuse. So that's really, what the employer can and cannot do under this new law. The law is enforced by the New York Department of Labor's Division of Labor Standards. There are no fines associated with violations. However, I did speak with a representative from the Department of Labor, and she informed me that if an employer is not compliant, that could be flagged in an audit that is done by the DOL. So you want to ensure that you're complying with this law, even if there are no fines associated with it. There's also, just so you know, there is no private right of action under this law. So if an employer violates this law and the employee who is affected by the violation wants to sue, that employee cannot do so. The employee would have to file a complaint with the Department of Labor instead. And so what do we do with this law now? What are some steps that we can take to ensure compliance? Of course, we should be reviewing our policies to make sure that they do comply with the new law. So reach out to your favorite bond attorney and get on that step. Another step that we can take is to definitely want to train our supervisors who may not be aware of these legislative developments. You don't want your supervisors demanding that employees under their supervision disclose their login information, because that would be a violation. So it's important that we make sure our supervisors are educated in that regard. Another step that employers can take is to consider or analyze whether, with respect to employees who may have access to company social media accounts for work-related reasons, you may want to put those employees on notice that they don't have any right to privacy in when using such accounts. So, if you have any questions about this, please don't be shy. Reach out to your bond attorney or give me a holler, and I'd be happy to address your concerns. Thank you, Gabe.
Emily, thank you. What an interesting issue, because there are so many permutations that one can imagine. There's one actually in the chat that I will let you address offline. But just a quick question, with clients that are coming into compliance with this, what are some of the themes you might have seen thus far, some of the issues that employers are bumping up against?
Yeah, so I don't know that too many people have really been looking to demand their employees to get their employees login information already. I know that a lot of employers are hesitant to go onto social media, and specifically with job applicants, for example. You have to be careful when you're hiring someone. You don't want to learn information when you're snooping around on social media that may be used against you in the future if, for example, you don't hire an applicant and then they claim that, oh, well, you didn't hire me because you saw that I was engaged, that I have some protected characteristic when you were snooping around on my social media, or you may observe them engaging in some kind of recreational activity that's legal, that they're going to now claim that you didn't hire them for that reason. So I know that a lot of employers are already careful about going onto social media and using information that they gain from social media against employees and applicants. And I think that's, to the extent that you're not doing that already, I think that that's something you've got to consider going forward. And certainly there are times when you get credible information from one of your employees about something that another employee is doing on social media. And the law specifically says that if someone voluntarily produces such information to you, you can still use that. The issue is when you think that one of your employees is Facebook friends with another employee and they both have personal private accounts, you cannot, coerce one of your employees into producing information from another employee's personal accounts. So you're absolutely right that there are a lot of nuanced situations that can arise. And I think when that happens, if you have any confusion, just reach out to your bond attorney to make sure you're not getting yourself into any trouble.
Thank you. That's very helpful, Emily. And please come back onto the program anytime you wish. We're really glad that you could make the time this afternoon. Let me now turn to our final presenter for the program today, who's Travis Tellerico, an associate in our Rochester office. Travis has been on the business program many times over, and today is here to discuss data collection in the EEO context beginning later this month. Technically, important for those of you who are in the position of bringing these data together and then reporting them to know how to do it. So Travis, please walk us all through. Thank you for coming back on.
Thanks, Gabe, and happy to be back. Hello, everyone. Again, Travis Tellerico with an associate in our Rochester office. Going to be relatively short and sweet for me today, but this is mostly a reminder for all employers who have to submit an EEO1 report in less than a month's time. So we're just going to walk through just a few basic things about the EEO1 report and the timeline for reporting this year. So if we want to just hop to our first slide. So just for some background for anyone on the call who is not familiar with what the EEO1 report is, on an annual basis, the EEOC collects workforce data from private sector employers with more than 100 employees. There is a lower threshold for employers who are federal contractors. That threshold is 50 or more employees. Now, to get ahead of what might be a question here is if you're an employer that might be hovering around that 100 employee threshold, to determine whether you are subject to reporting or not, per the guidance of the EEOC, to calculate that threshold, an employer must take a look at what's called a snapshot period, which is basically selecting a pay period from the period of October 1st through December 31st of 2023 and determining of whether you fall under the requisite threshold. To potentially get ahead of what another question might be there is, well, what if we are if our employee count fluctuates during this time period? There's a few weeks we have over 100, a few weeks under. That certainly would be a question I would advise raise with if you're either working with a bond attorney or a labor and employment attorney. What I probably could safely recommend is to not cherry pick if during the whole fourth quarter there you had one pay period where happened to fall under the 100 employee threshold count, to not select that pay period for your snapshot and say you don't have to comply with EEO1 reporting. And to my point about compliance is those that are subject to it, this is not an optional procedure. This is mandatory. If a private sector employer does have more than 100 employees, they must provide the requisite data for the EEO1 report. And that requisite data includes workplace data such as sex, race, and ethnicity broken down by job category. Next slide, please. So our time periods for this year, so the collection period has not opened just yet. That will be towards the end of the month on April 30th. And it is a relatively short period of time from when the period opens to when submissions must be filed. That deadline is June 4th. Now I have a few, just some information on here. If we look specifically at that hyperlink, if anybody wants to jot that down, or you can just go right on the EEOC website. But for any specific questions regarding what the report is supposed to look like, the specific data that is must be required in there, the EEOC does have a couple of instruction booklets and instructions on how to upload the data on their website. There is also a support center that the EEOC offers, which opens up at the start of the opening period on April 30th to assist filers with any questions that they might have regarding the collection. And just generally speaking, as a best practice, it would be advisable for employers subject to submitting a EEO1 report to start working on getting that data together sooner rather than later.
Well, Travis, thank you. I agree with the guidance that getting focused on this is important. So thank you so much for making sure that the audience had that reminder. There's a question for you in the chat, if you wouldn't mind taking a look at it. And with that, let me turn to closing remarks. I know that a number of you asked about COVID sick leave. Are we going to finally learn what's going on there? It's important to note that we don't have the budget language yet. We have this agreement in principle around the budget. When we actually see the budget language that ultimately the legislature will vote on, that's the point at which we can tell you more. So stay tuned. By next Tuesday, we should know exactly what has landed in the budget. There were some other questions concerning the workplace webinar, which certainly we'll work to address offline. But for those of you who haven't registered for the webinar, this is the information that you're seeing in front of you concerning the remaining dates. They're going to be through June and really all over the state. So pick a market that's nearby and know that we'll have bond attorneys there to help and guide you around the labor, employment, and human resources issues that are pertinent to your businesses. So with that, let me make sure that actually that's not the right slide with the content for today's presenters, but you can always reach out to me if you have questions concerning today's presentations, and I'll put you in touch with any of the presenters. It's goberfield@bsk.com. And I will be back with you in 2 weeks' time. In between, you'll be hearing from Kristen Smith. Kristen will be hosting next Tuesday. As always, we thank you so much for your commitment to the program and wishing you a beautiful day out there. Be well and safe.